Hi, my name is David Shapiro. I'm a San Diego-based criminal defense attorney, and today I'd like to discuss with you generally the charges in California of criminal threats and harassment. Criminal threats is generally prosecuted under Penal Code Section 422. It is a wobbler. What that means is it could be prosecuted as either a felony or a misdemeanor. Ironically enough, it's not only a wobbler, it's actually a strike felony if prosecuted. What that means is it's a strike in California is a serious or a violent felony as defined by the law. And 422 criminal threats is a serious felony under the law, which makes it a strike. So, this is an example why if you're accused or if you're arrested but not formally charged, it's really equally, if not more important, to hire the right attorney then, because from the prosecutor's perspective, when they get a case come across their desk, they're going to be looking at it and saying, okay, do we think the elements of criminal threats can be met? Okay, we believe it can. Then are we going to file it as a felony or as a misdemeanor? Not only are we going to file it as a felony or as a misdemeanor, is it going to be a strike felony or is it going to be a misdemeanor? The difference between the two is leaps and bounds between a regular misdemeanor and not only a felony, but a strike felony. So that's an example where you want a good attorney to look at the facts, examine the facts, present information about you, to go to the prosecutor and say, hey, listen, we might not have the police reports at this stage in the investigation phase as the defense. However, this is some stuff I want you to know about my client. And that way, hey, even if you guys are going to file these charges, we think it's appropriate not to file them as a felony and only file them as a misdemeanor. Criminal threat, so is another one of those charges that, on first glance, you may say, okay, well, oh yeah, that's definitely a threat. He or she threatened me, or he or she threatened that person. But you need to peel it back. You need to look at the law. Clients may be up in arms and saying, oh, that's not a threat. Well, you have to sit down, and the attorney you hire should have the competence and the skill to sit down and say, listen, these are the elements. This is why we believe it can be proven. These are the elements. This is why we believe it cannot be proven. So all those things go into it. Sometimes what may seem like a threat to everyone at first glance, under law in California, under the elements of 422, are not an actual threat. You could threaten someone indirectly, and that may not count as a threat, even if it was communicated to that person by a third party. So there's many defenses to these types of cases. There's many, a lot of times it's a he said, she said situation. So stressing the importance of keeping your mouth closed and don't corroborate that you made the threat. Don't confirm that you even had a conversation with that person, because those are all things that the prosecution would need to prove in order to even get the case that far.